Good day, and welcome to the Foley and Lardner Information Security and Vendor Contracting, Avoiding Common Pitfalls web conference. Today's conference is being recorded. At this time, I would like to turn the conference over to Ms. Yvonne Galinsky. Please go ahead.
Thank you for joining today's web conference. The title of today's session is Information Security and Vendor Contracting, Avoiding Common Pitfalls. Before I turn the presentation over to our presenters, I'd like to briefly offer a few housekeeping items for your assistance. If you have questions for our presenters, we encourage you to post your questions throughout the program by typing them into the Adobe Connect Questions Forum. If time does not allow for us to address your questions, we will follow up with you after the program. For audio assistance, please press *0. The program will last approximately 1 hour and is being recorded. Foley will apply for 1 CLE credit after the program. To be eligible for CLE, you will need to log into both the Adobe Connect session and the audio session with your first and last name and email address. Those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form that can be found in your registration confirmation email. Please enter the 4-digit code that will be announced during the presentation and return the form to S. Galinsky, that's SGALINSKY @foley.com immediately after the program. Please log into the program using the confirmation links provided to you. If you have any difficulty with the login process, please email my Foley colleague, Delia Dye, for assistance. Her email address is ddai@foley.com. And now I'm pleased to turn the presentation over to our presenters. Today we have Michael Overly, a partner at Foley and Lardner and member of the Information Technology and Outsourcing and Privacy, Security, and Information Management Practices, and Aaron Tantliff, Senior Counsel at Foley and Lardner and member of the Information Technology and Outsourcing, Privacy, Security, and Information Management, and Chemical, Biotechnology, and Pharmaceutical Practices, as well as the Healthcare, Life Sciences, and Energy Industry teams. Mike and Aaron are well-versed in all matters related to information security and data management. Mike and Aaron, please proceed.
Well, it's a great pleasure to talk with you all today, and thank you for taking time out of your days to participate. I'd like to begin with a little bit of an overview. Our discussion is essentially divided into 2 parts, and if we can move forward to the agenda slide, we can talk about these. But the 2 parts that I'm referring to are motivation and application. In the first part, motivation, which covers the first 4 bullet points on this slide, I'll talk about the motivation or reason for better integrating information security into vendor and business partner relationships. These are relationships where you may be entrusting a vendor or business partner with highly sensitive information. It may be a situation where you are granting these entities the right to access your facilities or systems, in which case they may have access to your data as well. In the second part, Aaron's going to talk about practical nuts and bolts ways to implement better integration for information security into the entire contracting process from front to back, including post-contract policing. As anyone who works in information security and privacy knows, there is a morass of guidances involving information security by organizations like the International Standards Organization or CERT at Carnegie Mellon. There are even non-binding guidances from regulators and financial services. There are intellectual property laws, such as those governing trade secrets, that call for efforts to ensure confidentiality and therefore security of trade secret information. There are contractual standards like the Payment Card Industry Data Security Standard, the PCI DSS. And of course, if we're talking about personally identifiable information, there are literally dozens and dozens of local, state, federal, and international security and privacy laws. That's a lot of information to digest and implement. In thinking about our discussion today, I actually thought a better title for our presentation would have been Information Security, Seeing the Forest for the Trees. In this first part of the presentation, we'll attempt to gain a better view of the forest rather than the individual trees that comprise the various guidances, laws, and regulations that may be applicable regarding information security. All too often what we see is businesses getting caught up on the specifics of a particular tree in the forest, focusing on its limbs and leaves, as opposed to losing sight of the surrounding trees and certainly not appreciating the overall structure and look of the forest. What we've tried to do is look at a very wide range of standards, laws, regulations, industry methods of protecting information. We've tried to distill all of that down to certain common threads that will hopefully permit businesses to bring the forest into focus. And we're going to talk about 3 of those common threads today. We believe that by gaining a better appreciation for the overall forest, businesses can do a better job of ensuring their information is protected and that they fulfill their legal obligations and other obligations like contractual requirements. As I mentioned in the second part of the presentation, Aaron will talk about how to apply these concepts to better integrate information security into the entire contracting process. And specifically, he'll talk about 3 tools that you can put to immediate use in your organizations to better achieve coverage of information security in your vendor and business partner relationships. The good news is that in our experience in hundreds of transactions, we have found that using these tools does not put undue friction on the transactions actually getting done. Rather, it's simply an ability to explain why certain things are being asked for to the vendors or business partners, and once they have a better understanding of that, in general, we've never had a situation where a contract negotiation is derailed over asking for these protections. So with those introductory comments, let's dive into the content, and as the slide on the screen shows, we're continuing to see a fairly growing number of instances, sometimes very substantial instances, in which personal information has been severely compromised. The point that I'd like to stress and that we'll return to frequently is the point made by the FBI, insider threat that poses very substantial risk to businesses. And by insider, the FBI is not only talking about employees and personnel, but also contractors, and that's a key point. And in fact, CERT recently changed, well, actually about a year or so ago, changed their definition of what an insider is to very much coincide with this, that it's not only business's own personnel which pose a security risk, but also the business partners and vendors with whom the business decides to interact. And so let's move to the next slide and talk about the types of organizations that would be enforcing. And of course, the Federal Trade Commission, the OCC if you're a financial institution, Health and Human Services if you are a healthcare provider, are all getting far more active. And the point here is simply that there's a wide range of entities that may take action. And of course, separate and apart from these entities, there is the threat of consumer actions, the threat of actions by business partners for whom their information has been compromised. Sanctions liability can be very substantial. Moving forward, we have some common misconceptions, and I think this is a point that, again, we'll return to one time after the other in our discussion today. The first is the problem of businesses believing that information security is a data-only issue, meaning that if the data is secure, all is well, and that's not the case, and we'll talk about that repeatedly. It's a theme. It's not only the data, but it's the security of the systems on which the data resides. And it sort of ties into the second point here, which is it's all about privacy. And of course, privacy relates to personally identifiable information of a consumer, but data security goes far beyond that. It talks about other information, trade secrets, business plans of the organization, sensitive information entrusted to the organization by a business partner, those types of things. And as I mentioned, it's not all about simply protecting the confidentiality of data. There's an acronym that is very common in the security industry, CIA, which stands for Confidentiality, Integrity, and Availability. And we'll discuss in detail in a moment what those requirements are, but it goes well beyond simply making sure that the information itself is confidential. It also means that the information must be reliable, that someone hasn't modified the information so that it can no longer be relied upon. Easy example, if you have a medical record and it's been tampered with such that you cannot rely on, say, a patient's allergies, it would be a critical problem. And then finally, the A, availability. The information has to be available when it's actually needed. If you're a bank and the account information for an account holder isn't available because the systems have been hacked, even though that information has not been actually compromised, it has not been used by an unauthorized party, the mere fact that it is unavailable creates a security issue. We'll see this concept of confidentiality, integrity, availability repeated in some of the laws and regulations that we're going to touch on. As mentioned at the beginning in my introductory comments, there's a whole morass of laws and regulations out there. Graham Leach Bliley in financial services, of course, HIPAA high tech and healthcare, lots of individual state statutes. We have a Federal Trade Commission with independent power to potentially enforce. So lots of potential areas out there. There are, however, relatively common standards, and we'll talk about that on the next slide, where we'll look at areas like Australia, the United States, and if we can move to the next slide, please, which require that a company act reasonably in addressing information security. In other jurisdictions, it might be worded in terms of taking appropriate action or necessary action. And so we have these sort of standards that are applied by various laws and regulations. Of course, there are contract requirements like the EU model contracts for data privacy, as well as contractual requirements like the PCI DSS. So what are we protecting? And that's the next slide. As I mentioned, it's not just personally identifiable information. It's general confidential information of the organization. Of course, it's intellectual property, trade secrets, source code to software, the formula for Coca-Cola. Any of these things must be protected. Of course, I mentioned HIPAA, GLB, non-public, personally identifiable financial information. On the next slide, so many times when we're talking about personally identifiable information, businesses will say, well, our customers are businesses, not consumers, therefore we need not worry. But every business has employees, and those employees have human relations data, healthcare data that the business may have. All of that may need to be protected and may be subject to laws and regulations. Of course, system operations, system integrity, other things that we're trying to protect by information security measures. Now, why are these protections important? Clearly to protect valuable assets of the business. Intellectual property, data may be the most valuable assets a business has. You also want to be able to establish that the business has acted diligently in protecting information and data. And this is a key point. One of the things Aaron will be talking about is documenting that an organization has been diligent, potentially by using an information security questionnaire with their business partners and vendors, so that there's a record that the company has thought through these issues and has tried to address these issues in a reasonable or appropriate fashion. Certainly protecting a business's reputation, avoiding public embarrassment. The last thing any business wants to do is be the front page story on the next edition of the business section in the newspaper because of a data breach. Minimizing potential liability, certainly for regulatory sanctions, fines, etc., but also direct liability to consumers potentially or to business partners whose data has been compromised. And then finally, everyone's talking about regulatory compliance, but as I've tried to emphasize, it's not just personally identifiable data that we're worried about. Of course, that's very sensitive information that must be protected, but there are lots of other types of information that a business must work hard to protect. So this brings us to the common threads that I described at the beginning. And again, what we tried to do is to look at a lot of different standards for information security, not just legal standards like HIPAA and GLB, but to look at, for example, the payment card industry data security standard, or we look at guidances from CERT at Carnegie Mellon. We look at ISO. We look at general industry trends to try and figure out, is there something, are there many things potentially, trends that run through these various standards, regulations, laws that are common, that can be found in each of them, that a business might be able to focus on in developing a plan to address information security. And on the next slide, we have found that there are basically three threads that run through the overwhelming majority of these requirements. In fact, pretty much most areas in the world have these sort of three concepts built into them. So the first one we want to talk about is confidentiality, integrity, and availability. And as I mentioned a little while ago, this is an acronym that has been used in the information security industry for years and years and years. It is a concept that security professionals return to constantly. And so when lawmakers and the folks that are promulgating industry standards decided to develop their standards and laws, one of the things they did is, in some cases, incorporate this language directly into the standards, laws, and regulations. And so you may pick up a particular standard and you'll see CIA referred to. And as I mentioned, it has three components. The first being the most obvious: the data has to be held in confidence, that unauthorized third parties cannot get access to and use of that data. It's fundamental. The next is integrity, which is that the data must be protected against unauthorized modification. In fact, there was an article written in a hacker magazine not that long ago that made a recommendation that if an employee was potentially going to be fired and has knowledge of this before their termination date, that one of the things the employee ought to think about doing is going in and corrupting the data of their organization, recommending, for example, that every single street address be incremented by 1 digit so that they are incorrect, changing credit card numbers or changing other information which would be critical for the business to rely on, and thereby rendering their database of information unreliable and potentially a great cost to correct. So understanding the idea that information must be capable of being relied upon and it has to be secured in a way that promotes that reliability, very important to the integrity aspect. And finally, availability. These are service levels. This is the idea that when I need the information, I need to be able to obtain that information. If we have a patient in the ER that needs to be treated, we need to be able to access the medical records of that individual rapidly. They have to be available for our use. If we are a manufacturer and we supply our customers with just-in-time products, we need to be able to have all the information available to us at the appropriate time to fill those orders. So the concept of confidentiality, integrity, availability is a concept that, first of all, is fundamental to information security, and second of all, is found in many, many standards. And so when one is developing an approach to addressing information security in contracting relationships, businesses need to think about it's not just a confidentiality clause. It's also a service level agreement in appropriate circumstances. It's also ensuring that means may be used and there are means available to ensure the integrity of information, that it is secured and reliable. And again, Aaron will talk about some specifics in just a moment. On to the second thread. This is a concept that I think is very much misunderstood, that perfection is not required under any statute or regulation or standard. Rather, a business must do what is reasonable or what may be appropriate or necessary, depending on the standard we're talking about, whether you're in the European Union, whether you're in Asia, whether you're in the United States. But the idea is that a business must act reasonably in trying to address a risk. And by reasonable, it means looking at what kind of data are we putting at risk, what are the availability of measures to protect that data? What are the costs of those measures? What is the practicality of those measures? And then doing what is reasonable. As mentioned, and Aaron will touch on this, part of doing what is reasonable is documenting that decision-making process so that there is a clear record that the business has thought through these issues and has tried to address these issues in an appropriate fashion. Then finally, the third common thread. And this is sometimes the most confusing. It is that information security requirements, as was mentioned, have to be reasonable. And part of that reasonableness is that they have to scale to reflect the type of risk that is being presented. And one of the things that we feel is a fall down in this area that we frequently see is that businesses may spend a lot of time and money developing a fantastic security document, an addendum that they might add to their contracts. And this might address a wide range of information security, everything from payment card industry standards to HIPAA to GLB, you name it, it's in there. It's a kitchen sink. It has everything possible and it's designed for very high-risk situations. The problem is there's no scaling in those documents sometimes. So if a business has a mailing list at risk, they would use the same document that they would use potentially to apply security standards as they would if they were engaging a transaction processor that would have very sensitive credit card information, or a record-keeping facility that would have medical records, for example. And the point here is that this will create friction on the contracting process, that trying to use a one-size-fits-all standard for all information security issues is generally not a great idea, because vendors will object. It may not be appropriate. It may make it very difficult to reach a contract that's acceptable to both parties. And so we're not suggesting that a business try to one-off their security requirements every single time, but some businesses will look at having a short form and a longer form set of security requirements they may use depending on the severity and risk of the proposed engagement. And if we move to the next slide, the point is that security isn't an all or nothing proposition, that there is a range of things that potentially should be done, and that the information security requirements should take into account that range. And one of the things that we frequently find is that fees are focused on, meaning that a company may look at a vendor relationship, and rather than focusing on what kind of data am I placing in play, the question is, how large is the engagement? Is it a $5,000 courier engagement, or is it a multi-million-dollar electronic medical record engagement? Now, of course, it's important to take a look at that scale. The problem is, though, if you're putting highly sensitive information at risk, regardless of the fees, security must be addressed in a reasonable fashion. And again, what we point out here is that this is a concept that we see in laws all the time. And on the next slide, we have an example from the Massachusetts Data Security Law, which everyone has likely read about. And it makes clear we need to take into account the size and scope and type of the business, the amount of resources available to that business, the amount of data that's being placed in play, the need for security and confidentiality. On the next page, we see a very similar sort of approach with the HIPAA Security Rule. We look at the size and complexity and capabilities of the covered entity. We look at the covered entity's technical infrastructure, hardware, software, security capabilities. We look at the cost of security measures, the probability of the risk being presented. These types of things need to be taken into account. So the three common threads that we see running through a lot of these standards, a lot of these laws and regulations, are actually very straightforward. Confidentiality, integrity, availability, the first thread, something that's been around in information security work for a very long time. The second, acting reasonably, acting appropriately to address a problem. Perfection is not required. And then finally, this idea of scaling security to meet the risk presented, which we think is a key thing. And again, it's an area where we see some businesses requiring sort of a one-size-fits-all approach to information security, and that frequently causes problems in vendor relationships. And so we're simply suggesting that businesses potentially think through that one-size-fits-all approach and potentially develop plug-and-play provisions that we're not going to require PCI language if cardholder information isn't going to be in play. We're not going to require HIPAA-related language if protected health information isn't in play, etc. So that there is this scaling that is contemplated by the statutes, as well as the overall requirement of doing what is reasonable to address the problem. And with that, I'm going to turn it over to Aaron, who will talk about the nuts and bolts ideas of applying these common threads to a situation that almost every business experiences, likely on a weekly basis, which is contracting with others, whether they be a business partner or a vendor, that may result in a business partner or a vendor having access to the company's systems or data. And with that, Aaron, I'll let you take over.
Well, thank you, Mike. It was a pleasure listening to you there. And Mike taught us a lot about the why are we doing this, and I'm going to now spend some time on the how do we actually go about doing this. But before I do that, I just want to correct something that Mike had said. He had made a claim that you have a short version and a long version. And actually what Mike didn't tell you is that we actually have multiple versions of that. We also have the short, the moderate, and the long. I mean, these come in a variety of flavors, but one of the most important things when Mike had talked about in the beginning about how we really haven't encountered significant pushback or difficulty in having these negotiations, it's really because, as Mike had mentioned, it's really understanding the situation and the nature of the information and really getting in there and utilizing the correct tools, the correct terms, the correct exhibits and provisions in order to really make everything appropriate and to really have the proper outcome. So there's actually, as I'm indicating, there's a number of different flavors, and also it depends upon the type of industry that you're talking about. Certain laws or regulations or other types of agreements may come into play as well. So with that, let me talk about the three-step approach that we're going to discuss today. And for a good portion of this presentation, or the rest of the presentation, one is sort of the vendor due diligence process, and that's really what you're talking about when the company is looking to bring in these third parties, the independent contractors, the service providers, and other people who are going to have access to their systems as well as their information. You're talking certainly about your highly sensitive information and systems that have access to that. And oftentimes we see, generally speaking, that this is somewhat of an informal process. There's a couple of people who talk back and forth, ask a couple of questions, but there really isn't so much a uniformity in the process, and we'll talk about that a little bit more in just a few slides. The second one we're going to talk about is that after you've actually gone through that due diligence, how do you incorporate that into your contract? What do you need to do to ensure the proper protections? And then finally, we want to talk about, what are those procedures that once you have all these procedures, once you've done your due diligence, you have your provisions in place, how do you incorporate those provisions in the way that information is handled, both in the agreement as well as with exhibits to the agreement. So with that, we're going to quickly talk about some common errors, and then we'll get right into the three-step process. So the first one is sort of really the failure to involve all relevant stakeholders. And if you think about it, that there's a number of people who are going to play an important role in trying to safeguard your information. So that could be people all the way from, on one hand, legal and HR, people who develop processes and policies and monitor sort of what is required, what needs to be done, information technology or information services, how is the information actually protected. You want to think about the nature of the organization, whether you have labs or research centers, who knows what the information is that you're trying to protect. So you have to get everybody involved in order to properly protect that information, because otherwise you may miss out on a pool of information. You may miss out on your research center, your development center. You may not realize that you have certain types of information in your facilities, and that you need to ensure that you have protection for that. But also, certainly, we've heard a number of times that the privacy or the IS or the IT groups are sometimes left out of the process, and they're handed a bunch of policies to implement, and it wasn't properly thought through, and it may be more difficult to implement those policies and procedures in the manner that they were proposed, but there may have been a better solution if they had been involved in the beginning. Also, it's important to also understand how are you trying to protect it and sort of what the situation is at play. So, what is the technology? What is the media? In this case, we have an example of mobile applications. You have to think about where is the data going to be. Is the data always going to be within the confines of the physical structure of the building, and you have to worry about, you have certain precautions on how information may flow externally, or do people may have, mobile devices, applications, and that information may freely flow outside the walls of the company, and you have to worry about information, maybe on a mobile device, and do other applications have access to the information? Do other people have access? Is the device shared? What is the totality of the universe that this information is residing in? And how does the system, the inner sanctum of it, get breached as well? And then you have to, sort of the inflexibility aspect of it is really, times change, technology changes on a rapid basis, the way information is handled and stored and transmitted, it changes all the time. And if you have a policy in place or procedures in place and you don't adapt it based upon new technologies, new developments, new ways of utilizing the information, you're going to find very quickly that your policies are unable to protect the information at hand. So, as I said, moving on now to step one, sort of the due diligence. it's important that as part of any process, before you bring anyone on, before anyone has access to your systems or access to your information, or they'll be handling, you really want to think about how you're going to select that vendor, and you really want to create some type of process, some type of vendor due diligence, because you want to make sure that you have sort of uniformity, that you want to make sure that you've asked all the questions that need to be asked, and you want to make sure that your vendor knows up front that you're going to, that this due diligence task is not just, sort of to placate you during this process, but it's really going to become part of the contract. So you really want your vendors to sort of dig deep and really think about the answers to these questions and put down in paper what it is that they're actually doing and how they're actually doing it. Because oftentimes we see that you may go through this process and the vendor says, you know what, that's great, we've told you what it was a bunch of whole marketing, but you can't put that into the agreement, we're not going to honor that. And so you may have wasted a bunch of time, you may have selected your vendor and sort of determined that that whole process may have been for naught. And that's sort of a very important aspect of really the due diligence process. So as I was saying, one of the important things is to make sure you have sort of a uniform framework. And one of the reasons why is that you want to make sure that when you're able to compare apples to apples, as we have here, and that you want to make sure that when you're talking to one vendor or another vendor or all the vendors, that there's a uniformity, that you're asking the same questions, that you really can compare vendors, because when you do this sort of offhand, you may forget to ask certain questions, or you may ask different types of questions, or phrase them in different ways, and you may just not have the proper information to compare one vendor to the other. But also having sort of a developed process will enable you to really make sure that you've hit every question that you need to, that you didn't leave anything out. Oftentimes you have to think about, what are the regulatory compliance requirements, as Mike had mentioned. What's the nature of the information? You want to make sure that all of those questions get asked. But also, when you have a really well-defined due diligence process and sort of due diligence questionnaire and they're answered, it makes it really easy and convenient to take that document with the questions and with the answers and attach it as an exhibit to the document. So especially when you go out and you talk to the vendors and you ask them to fill this out, you let them know that this will become part of the contract, they fill it out in the document, they send it back to you, and now you're all set. Really, it takes about a minute maybe to attach it to a document, and you're all set with that part of the equation. So continuing on, you want to make sure again that when we talk about what goes into the due diligence questionnaire, there's a whole bunch of items. You want to talk about what are those, whether you have any particular laws you're required to comply with, and whether or not you also want to use this as a way to assess whether your vendor truly understands what it means to comply with these regulations, and really if they understand what these regulations are. We've unfortunately found a number of times that vendors will respond and say, sure, we can do that, or sure, it's not a problem, and they think they may look it up, they may go online and copy and paste some information, or they say, we protect our information, I'm sure it's not a problem, but it turns out, obviously, certain regulations and compliance requirements have sort of different requirements on how you are going to encrypt information, whether information may be transported, cross-border. So you have to think about what that's going to be. And really, so when you develop this questionnaire, you really want to think about providing enough information in here that's also an education to your vendor to make sure you're on the sort of the same playing field, so that your vendor, when they're answering the questions, they really know what it is that they're signing themselves up to. So with that, though, I am going to pause for just one moment before I continue on with the slide. And for those of you who are seeking CLE in New York, New Jersey, and Kansas, the CLE code that you need is DV, the number 1I. And again, that CLE code for those in New York, New Jersey, and Kansas is DV, the number 1I. Okay, so with that, back to our questionnaire, or how are we developing the questionnaire. So a couple of things you want to think about, again, as I was mentioning just a moment ago, you want to think about all of those particular laws and regulations, ordinances, and whatnot that really play a role in your organization, that the information that's part of that's within your company that needs to be protected, that information, that those laws, rules, regulations, ordinances, they're all included in your questionnaire, and really explain them in a way that your vendor understands what it is they need to do. You also want to make sure that you ask questions about what are their information security policies and procedures, generally speaking. So forgetting, any particular law that may apply, but how do they generally protect your information? What are their security policies? When was it updated? How often is it updated? What's the policy of doing so? Have they conducted any type of audits from on their systems, on their policies? Have deficiencies been found? Have they been corrected? So you want to think about those types of things. You also want to think about their financial condition. Is this a company that's at risk? What happens if you have a company that goes out under and they have access and they have possession of all of your highly sensitive and confidential information? You want to think about, are you going to get audit reports or financial reports, I should say, from them in order to determine their financial stability? And again, what happens depending on the way this vendor is incorporated into your environment? Do they possess that information in a manner that you need to get it back from them? Do they possess just a copy of it? Can you delete it from them? You also want to think about things like insurance. What type of insurance do they have? What's going to happen if there's a claim? What's their policy on, hiring certain types of people who may have certain types of convictions or criminal convictions, or how often are they involved in litigation or claims? You think about, again, who's going to have access to your information? Do they provide all the services with their own individuals, or do they use third parties and contractors and subcontractors? Do you know who they are? Are you going to limit them to the types of information they can have access to? Maybe they only have access to non-sensitive information or sort of back-end systems, but they stay away. I mean, you have to think about, do you get to screen those individuals as well as the contract, as well as the vendor's personnel? How do they handle procedures and policies? How do they handle their own information? What do they use to secure your information? The physical, the administrative, the technical safeguards. What information gets encrypted and how does it get encrypted? You also want to think about, sort of, again, what are their policies? What are their privacy policies? How do they use information? How do they collect information? What happens if their systems go down? What are their backup plans? What are their disaster recovery and business continuity plans? Are they viable? Have they been tested? What's the time for it to come, for recovery? Is it a hot site, a cold site, warm site? What happens when these systems go down? What's the protection and sort of what's the insurance that your information will still be there? You also want to think about, finally, in terms of software that's being developed for you, is that software tested? How do you maintain sort of the beta software, the developed software, separate from your own software, your sort of finalized production version of the software? So moving on to sort of finishing up step one here, I want to bring up, again, which I mentioned earlier, you want this questionnaire sort of brought up as early as possible. And really one way to do that is that if you have an RFP process, you want to stick that questionnaire right into the RFP. If you don't have one, when you start that initial discussion with the vendor, you want to stick that questionnaire in front of them because you may not want to move forward with them. So step two is sort of the contractual protections. You want to think about, there's a whole bunch of different types of protections that we want to sort of put into place, that we want to make sure are there based upon, again, sort of the type of information that we have. So these provisions will change based upon highly sensitive, it's not so sensitive, certain, depending on the nature of access, again, as Mike had mentioned, mailing list, credit card information, financial services, personal health information, sort of all changes. But one of the things that's important, and I was just having this discussion before, in a discussion that something that was brought up to me last week, in terms of at the highest level of security, we can put in all of these provisions, which we'll discuss in a moment. We can talk about the questionnaire, we can get all this information together, but at the end of the day, your document, one of the things which I didn't anticipate how much it's actually missing, is who is responsible for what. We may have protections as to, do certain things get done, how do you protect information, what happens if there's a breach, but somewhere in the middle is to make sure all of these things, you want to make sure somebody is doing them, whether it's background screening, who's screening the people. We know that everyone's going to have a background screen, but is it the company, is it the vendor, who is it? Because it turns out that sometimes Some companies may, or in some engagements, think the other one is responsible for ensuring that when people enter a facility or leave a facility, to check to make sure they don't have contraband on them, to make sure they don't have materials they shouldn't be taking out with them, to make sure their background checks, you talk about criminal convictions, or they may have allegiances to nefarious groups that you want to be careful about. So that being said, let's walk through some of these provisions that we want to talk about. And one of them is sort of your NDA or confidentiality. You want to think about what that is, how are you talking about it, and this is really going to be sort of one of the sort of cornerstones of these types of agreements, is that a really fully fleshed out confidentiality clause to ensure sort of the information protection. And the way that's flushed out may depend on when you're talking about health information, financial services, you're talking about, or mailing lists as we talked about, but you really want to make sure that you also address the types of information that you're going to have, whether it's source code or marketing plans or, again, health information, whatever that may be. And then you want to think about, a lot of times you'll see a provision that will say that the term of confidentiality is 3 years or 5 years, whether it's after the information is disclosed or after the termination of the agreement. And some of these things may be appropriate, some of them may not. And certainly you may have to figure out when information was disclosed. But one of the most important things, and we're talking about here, are some of your most sensitive information, your trade secret information. So no time limit is ever appropriate, because as long as you keep it as a trade secret, so should your vendor, third party, or employee, or whoever else has access to it. Otherwise, one, you're not taking reasonable precaution to ensure that it remains a trade secret or that it's highly sensitive or proprietary, but also you want to make sure that the information doesn't become publicly disclosed. You also want to think about, again, your general security obligations. What are those things that the individuals need to do on a day-to-day basis? They may include the use of external drives. We can certainly spend a lot of time on sort of how that works, and that will be part of step 3 as well. Sort of your security and data warranties. You want to think about, at the end of the day, your vendor has provided a whole bunch of information as to how they're going to comply sort of on that due diligence vendor questionnaire, and you'll have some warranty provisions, but at the end, or other provisions, but at the end of the day, what happens if they breach that? You want to make sure that they state that all their answers are true and accurate, that if they breach whether it's the vendor questionnaire or any other warranty set forth in the agreement, that you're going to have a remedy against that. You also want to make sure that they have, depending on the nature of the information, they don't send, for example, health information or financial information, whether it's offshore, to parties who shouldn't have access to it. You also want to take a look at, again, with the nature of the subcontractors, that who are they providing the information to? We talked about this already. You want to make sure that they only provide information to those people that you're made aware of, that you agree to, that they won't provide information to a subcontractor or a third party if they haven't been pre-cleared by you or you haven't given their consent. So we're moving on to some additional contractual protections. You want to think about at the end of the day that when there is a breach sort of notification, that, and we'll talk about this in connection with the limitation of liability as well, is what do they do? What are their obligations when they're made aware of a threat or a potential breach or a real breach? What do they need to do? How do they need to contact you? What are their jobs to secure all the information internally within the organization to make sure you can provide your proper investigation so you can determine what information has been leaked, whether it's proprietary, sensitive, trade secret, whether it's identifiable information of a third party that you may need to notify third parties and provide insurances to those individuals, whether it's credit checks, whether it's investigation, fraud control, and you have to think about that. Whether or not who's going to be responsible for those costs. You want to put the vendor in the position that if they're protecting your information and they fail to do so, that they're going to be responsible for all the costs associated with that breach notification, that there will be significant ones in sort of the investigation, credit checks, and responding to third parties. You want to think about third parties who will then bring claims against against the company for breach of their information. You want to make sure that your vendors provide you a full indemnification against any claims from those third parties. You also want to take a look at your limitation of liability. A lot of times in these agreements, there's going to be limitations that's going to prevent someone from prevent you from really getting reimbursed when a claim does occur. You want to think about whether or not that information, whether or not you actually have a real protective contract or whether it's just illusory. Whether or not you're actually going to get anything back. So you want to make sure that even when you have a limitation of liability, which sometimes are difficult to cut out of an agreement, that these things with regards to breach notification, indemnification from these third-party claims, whether we're talking about the warranty, failure to abide by, the provisions, in that, or, how they're going to secure your information on the questionnaire, that all of those things are sort of carved out of the limitation of liability, so you actually have real protection. And again, their insurance we talked about as well, and again, the incorporation of the questionnaire. So moving on, so to now step 3, sort of how you're going to handle this. So a lot of times, and as Mike had mentioned, that there's different types of amendments that you can attach to agreements. There's different types of provisions that you set forth how information is going to be secured and protected. We can talk about those documents, depending on the nature of the information, how you're going to secure your information, what restrictions you're going to put on the individuals, what they can or can't do, the requirements to encrypt, how are you going to encrypt, what methods you're going to do to do so, how are you going to destroy the data after it's no longer needed, or the vendor or the relationship is over. There's different ways to destroy data. There's different obligations to do so, and you want to make sure that those guidelines that you have in compliance with particular regulations are in that exhibit as well. You talk about removable in media. Should you allow removable media or not? That's a question that may be in there in terms of your environmental security. Do you allow access to removable media? Can people put information on them? If so, how do you ensure the protection and the security of that? And then sort of how do you communicate throughout the organization all of the information, whether or not there's been an incident, whether or not, what's the sort of chain of command, who talks to who, how does that information get from the vendor to the company. So moving on. So we're going to talk about quickly some negotiation tips, and then we'll try and get to some of the Q&A as well. So in terms of negotiations, we talked about you really want to raise these things at the outset, including, your liability expectations. Again, can't say that enough. We've said that throughout this presentation, that's something you want front and center in the beginning, because if a vendor won't provide you that, you may not want to be doing work with that vendor. You also want to take a look at sort of how you sort of present this information, and there are different ways of doing so. Mike had mentioned that you really want to take a look at what's appropriate, how you want to do it. You really want to approach this from the vendor that the two of you are a team in securing your information, that this is a sort of a process that really revolves the cooperation of both parties. You want to make sure that any type of, again, rules, regulations, laws, that you really educate the vendor. You want to make sure that they understand what it is they're complying with. So we've never really had we never really had major pushback on this, but again, we want to talk about flexibility. We've talked about that already as well, but think about that in the process, it's probably not going to happen that often where you're going to hand them a form or hand them provisions and it won't get revised somehow. And you want to think about having some flexibility, but where it's appropriate, you certainly don't want to mark up or take away, the core protections that you need. You also want to think about, oftentimes you talk about sort of having at the ready alternative provisions, almost like a playbook, that if something doesn't work, how else can you approach the situation with alternative provisions that may work. You also, there's also, you hear often from vendors talking about they can't change the way they secure systems on a single engagement, and a lot of times you need to really understand that it may be that the vendor has ways that they're securing it that are appropriate. You want to sit down and talk with the vendor what are they doing, because it's possible that what they're doing may be appropriate and may not be, but you have to get the wording correct. It also may be possible that the vendor, in some cases, may not be protecting any information appropriately, considering the field that they're in. And so, but you really do want to take a look at that and figure out really what the vendor is doing, because sometimes it's really just a language barrier. And as well, and part of it is that, the other thing is the vendor will sometimes say that that you're changing the way the vendor operates, or you're moving it away, you're changing its security standards. And quite often, again, a lot of times it's really more of a language issue than it is anything else between the vendor and the company as to how or what the security provisions are, because if they have other clients in the same space, it's very unlikely that those clients, unless they don't know what the requirements are to protect their information, that they don't have the same requirements from company to company or client to company. Understand that at all times, sort of the language sort of changes. You want to think about industry best practices. Really, these things evolve on a regular basis all the time. There's new laws, regulations that come out. There's new interpretations. There's case law that really sort of dictates, really what is current, what is best, and really one of the best ways to ensure proper protection, or sort of the best protection you can, is really what are the best practices, and making sure your vendors are following those. And also think about, a lot of times you may see a blanket provision that says you will comply with those laws and regulations that are applicable to your space, to your vendor, but you have to think about what's the nature of the information that a company may have. A company who's not in the healthcare space may have personal healthcare information through its HR systems or claims management. A company also may not be in the financial services space, but may have certain financial information on its individuals. So you want to think about really what is applicable. And then following, sort of one of the things to think about, once you have all this said and done, one of the things that's very critical or very much important, you spend a lot of time talking with your vendor, a lot of time going through questions and answers, is you want to think about auditing. You want to make sure that it's great on day one, they may be in compliance, but what about day 2 and thereafter? You want to make sure that you have the ability to get in there, audit, make sure they're compliant. You want to, if they aren't compliant, address it before something significant happens. You want to make sure that you have the ability to get in there on a regular basis, but at the same time, you don't want it to prevent the vendor from being able to conduct their business. So you want to make sure it's a fair process, but you also want to make sure you have access to whatever it is that you need to have access to. And then you want to think about that the vendor is going to provide you sort of on an annual basis, that they are compliant with all those things in the agreement, that an officer of the company signs off and it's notarized, that they understand what the requirements are, that they are in compliance, because at the end of the day, if there is a breach or there is a violation, this is just another feather in the hat as to go back to the vendor and say, you were clearly in breach of the agreement, you said you were doing X, you didn't do X, and why happened. So things to think about. But with that, I want to make sure we do have some time for some Q&A, so I'm going to open it back up and ask Mike to join me yet again as we try and get through some of these questions here.
Sure. I think we have a question about, someone had said, is it appropriate and is it sufficient to have a vendor, if there is a breach, agree to pay costs as required by law? And that's certainly very useful, except the costs required by law generally are mailing costs or other distribution costs. Generally don't include, for example, what is now common identity theft insurance for a period of a certain time, normally 1 to 3 years. And there's, no real responsibility for harm to the business's reputation in the form of consequential damages, lost profits as a result of the disclosure, exposure to fines or sanctions. So it's a very good start, but generally it's a start only, and we would expect to add to something like that. Aaron, what do you think?
Absolutely, I agree. I mean, one of the things is that, you're talking about sort of with law, which law are you talking about, whether federal or state? And a lot of times laws don't really address, in a lot of cases, what those costs would be. They say that, someone's going to be responsible, but, you think about breach notification, you talk about, sort of the identity theft insurance. Well, is that really law in every jurisdiction? Is it, in some cases, isn't it just industry practice or industry best practice? Do you want to think about, just as Mike had mentioned, there's a large category of things that would not be included in the law, but even so, and I would venture to say that the majority of the costs that you're going to want to seek reimbursement for have nothing, aren't set forth in any law. And I would find it hard to believe that we're ever going to see a law that's going to lay all those costs out, because I don't think our legislators are going to really want to get into that into the weeds in that way.
And one point to make is that our goal in the discussion that we had and the recommendations that Aaron was making is not to set up the world's best lawsuit in order to hold a vendor liable and potentially bankrupt their company. The idea is that we want to avoid at all costs that situation. And the best way to avoid at all costs that situation is for the vendor to understand they've got real exposure if they go ahead and disregard these requirements. And so to our point, it's kind of the classic, we want the vendor to have some skin in the game, that if a vendor knows that if they fail to comply with all of these requirements, their maximum liability is 2 months' worth of fees paid, that vendor doesn't have a lot of interest in trying to comply, which is one of the reasons why we press for responsibility, because that tends to force the vendor to actually be responsible. We want to talk about another question that came up is, under what law would a third party sue for breach of their data? And of course, it depends. It could be a business partner, in which case they might not need a law. They might have a contract where there is a confidentiality clause, and its business partner, meaning your business, has breached it because one of your vendors has failed to protect the data adequately. So it could be a breach of contract action. It could be a violation, as the FTC does, of your own privacy policy, where there might be a possible action. The individual might allege negligence. Some laws do include private rights of action by individuals, so there are lots of possibilities, but there isn't necessarily one specific solution. Let's see, Aaron, we have one more, I believe, that just came in.
Yeah, I think it's third party, when vendors use third parties to execute the agreement, to what degree the contractual obligations extend to them, any recommendations, and what's the standard posture here. I think there's two ways of answering that question. I guess I want to make sure, we'll sort of address both quickly. We talk about when vendors use third parties to execute the agreement. I think, sort of third party contracting organization versus, which I think is probably more likely, is that what happens when there are third parties involved or subcontractors as well, and how do you extend the contractual obligations under your agreement to those third parties? I hope that's correct. If not, furiously type and let us know, or we'll address that after the fact. But certainly I think there's a couple of, you have sort of the standard initial way, which is always that, all these provisions that if there's going to be any types of third party, well, let me back up 1 second and say it really also depends on the nature of the information, the type of entity, and really what we're talking about as to whether or not, how significant this issue may be in terms of, and also what the nature of the material is or the information. Once we get to that point, you certainly want to make sure that any provision under this agreement will extend to the third parties. And the question then becomes whether or not you want to allow third parties to be used as is, or you want to have the right to accept or reject third parties, or you want to do your own due diligence on them and enter into your own agreements with them. But sometimes we also have exhibits where the third parties, or where the company gets to be a third party beneficiary underneath the agreement with the subcontractor, so that the company can enforce its rights and directly against those subcontractors. I'll turn over to Mike to fill in.
The only thing else I would add is that in certain very unique situations, definitely not recommending this in a normal contracting situation, but you have a situation, say, a very critical vendor that is nonetheless financially unstable, or maybe there's just a reason that they're deciding to host the majority of what they're doing with a third party. So the vendor is subcontracted out, doesn't have the assets to do it themselves, or maybe they just don't want to do it themselves, to a third-party data center to host their data, and that data is extremely sensitive to their customer. In some instances, the customer may pursue a direct, quote, subcontractor NDA with that third-party hosting facility. Obviously difficult to negotiate, but it's a highly customized NDA that explains what the relationship is and then requires the primary vendor to, if you will, leverage their relationship with the data center to get the data center to execute the subcontractor NDA, which would then give the customer direct contractual privity, at least with regard to confidentiality, sometimes with regard to some information security requirements, so that there's a direct possibility of enforcement. Again, used only in unique circumstances, but we, in representing financial services companies and healthcare providers, have done that a number of times, and it's proven to be effective. But, you know, it's always a difficult situation when third parties are involved.
So let me just answer, because I can do this one really quickly, sort of the last question, or the one that just came in terms of a sample list of scenarios, in terms of when you should seek, or when the vendor should, provide, or I guess when covered by the vendor's obligations for notification, for costs. I mean, I would say this, the answer is somewhat simplistic in that certainly any instance where a vendor has violated or breached or not performed in accordance with the contract, certainly think about, is there any breach of that questionnaire? Did they say in that questionnaire, in the warranty, in the agreement, in any exhibit, that they were supposed to do something? And did the breach occur, or the incident occur as a result of their failure to do so, to abide by that? Was it because the vendor had a discrepancy in an audit and failed to correct that? So you think about all those things the vendor should be doing and didn't do. That's a good start, I think.
Completely agree. If there are any other questions, as Aaron pointed out, do not hesitate to shoot either of us an email, and we'd be happy to respond. I know there are a couple of others that we didn't get to, but we very much appreciate your attention today.
So I will, at this point, I'm just going to draw everybody's attention to the particular slide that's up on the screen at the moment. There's a survey on there, and I think somebody could discuss that a little bit more, but certainly we encourage you all to click on the link for the survey to let us know how we did, and certainly if you'd like Mike and I to provide any further topics of discussion, Mike and I have done a couple of these already together, and certainly we look for your feedback to tell us what you'd like to hear next. Included in the packet that you have here is, as you see on this last slide, is my information as well as Mike's information. Feel free, as Mike said, to reach out to either one of us, both of us, or none of us with any questions that you may have. And again, we encourage you, like on the slide before, to click on the link and please take the survey. So with that, I think we are done, and thank you for joining us today for our presentation on information security.